Welcome to another edition of The Walkthrough, your deep dive into the forms and contracts that power your business. I'm Byron King, Chief Legal Counsel for South Carolina Realtors.
And I'm Tiara, Ethics and Legal Compliance Counsel for SCR. Today we are taking an in-depth look at the March 2026 update to Form 130, our exclusive right to buy or lease buyer-agent contract.
Before we dive into SCR Form 130, we must begin with a critical reminder regarding antitrust laws. Real estate commissions, fees, and terms of services are not set by law, nor are they fixed, controlled, or suggested by the South Carolina Realtors, any local board, or the MLS.
That's right, Byron. All compensation is strictly a matter of independent negotiation between a brokerage and their client. In this video, we're going to explain how the form functions and how to complete it, but we will not discuss specific commission rates or standard fee amounts. Our goal is to help realtors explain their own brokerage services and pricing structure with confidence.
Today, we are walking through the March 2026 revision of SCR Form 130, the exclusive right to buy or lease buyer agency contract. This is the agreement that establishes the agency relationship between a buyer and a real estate brokerage. It defines the scope of the broker's services, the buyer's obligations, and how the broker will be compensated for representing the buyer. This form is now especially important because compensation for buyer brokers is no longer automatically offered through the multiple listing service or listing agreements. Instead, buyer-broker compensation must be clearly negotiated and disclosed with your buyer up front.
So let's go into Section 1, Appointment of Broker. This section establishes the agency relationship between the buyer and the brokerage. By signing this agreement, the buyer appoints the broker as their exclusive agent for the purpose of purchasing or leasing property. This means the buyer agrees to conduct all negotiations through the broker. If the buyer is contacted by another broker or a seller or any party about a property during the term of this agreement, the buyer agrees to direct them to their broker. This section is what clarifies the fiduciary relationship between the broker and their buyer.
Section 2, Purpose of Agency. Section 2 defines what the type of property the buyer is seeking and the general parameters of the property search. This includes the type of property, price range, general location, and other preferences. This section is important because it defines the scope of the broker's representation. If a buyer purchases property that falls within these parameters during the term of the agreement, the broker's compensation may be earned. It is also important to understand that a buyer could have more than one buyer agency agreement if each agreement covers different parameters, for example, different locations, types of property, or price ranges. As long as those agreements do not overlap in scope, this would be appropriate.
Exactly. And Section 3 is length of agreement. This section defines how long the buyer agency agreement will last. This agreement begins on the date it is last signed and continues until the expiration or completion or termination of any then pending transaction, whichever is later. It's important to note that this agreement cannot be terminated unilaterally by one party. If the buyer or broker wants to end this agreement early, both parties must sign a release. In simple terms, a client cannot fire their agent with an email. Proper termination would be done by both the buyer and broker signing Form 255, the conditional release form.
Section 4, Broker's Efforts. Section 4 outlines the services the broker agrees to provide to the buyer. This includes locating suitable properties, touring properties, negotiating offers, and helping the buyer secure a purchase contract. This section also contains an important compliance reminder. A broker may not represent that their services are free or provided at no cost if the broker will receive compensation related to the transaction.
Now let's get into Section 5, which we've been getting a lot of questions about. This is the dual agency section and the consent to dual agency. So Section 5 addresses disclosed dual agency and designated agency. Buyers must initial whether they are willing to consider these type of agency relationships in a future transaction. This does not automatically create a dual or designated relationship. Instead, it confirms whether the buyer is open to considering that possibility if it arises in a specific transaction. If a dual or designated agency situation occurs, a separate written agreement will still be required. Now let's break down what exactly is dual agency versus designated. So, dual agency happens when the same brokerage represents both the buyer and the seller in the same transaction. In that situation, the brokerage is working with both clients at the same time, so the brokerage must remain neutral and cannot advocate for one side over the other or share any confidential information between the parties. Designated agency is slightly different. In designated agency situation, the broker in charge assigns one agent in the office to represent the buyer and a different agent to represent the seller. Each agent can fully advocate for their client while the broker in charge oversees the transaction and ensures confidential information is kept separate. If you have any questions about that, please go to your broker first and then follow up with the SCR Legal Hotline.
Section 6, Buyer Duties. Section 6 outlines the buyer's responsibilities under this agreement. The buyer agrees to work exclusively through the broker for real estate activities related to their property search. This section also allows the broker to provide a copy of this agreement to the closing attorney for purposes of verifying representation and compensation. Section 7, Broker Fee. Section 7 is one of the most important sections in the agreement. This section defines how the buyer's broker will be compensated. The buyer agrees that the buyer broker fee is earned when the buyer enters into a contract to purchase property that was presented or negotiated through the broker, and payment is delayed until closing. The form provides multiple options for structuring the brokerage fee, including a percentage of the purchase price, a specific dollar amount, or another negotiated structure. The form also allows for additional fees such as retainer fees, bonuses, or administrative fees. Broker fees are not set by law and are fully negotiable between the broker and the buyer.
Now let's talk about sellers' contributions toward buyer broker compensation. This section also explains how sellers may help cover the buyer broker fee. Buyers may ask for a seller credit at closing to help pay some or all of the broker fee, or the seller may agree to pay the broker fee directly through a separate agreement, such as Form 120. However, it is important to remember that the buyer remains responsible for paying their buyer's agent under this agreement, even if they attempt to negotiate that payment from the seller. Please remember that you can only receive the compensation that is agreed to in Section 7 of this form. For example, if you enter 0 in the bonus section and the buyer purchases a property where a bonus is being offered, you would not be able to accept that bonus. So it's important to know your value, explain your services, and make sure your compensation is properly reflected in Form 130.
Protection period. This form also includes a protection period. This means that if the buyer purchased a property that was introduced by the broker during the term of the agreement, even after the agreement expires, the broker may still be entitled to the broker fee. Section 8, Other Buyers. Section 8 addresses the possibility that the broker may represent multiple buyers at the same time. This is common in real estate practice. If two buyers represented by the same broker compete for the same property, the broker must provide written notice that confidential information will not be shared.
Section 9 is our fair housing section. It confirms that all actions under this agreement must comply with the Realtor Code of Ethics and all local, state, and federal fair housing laws. This includes protections against discrimination based on race, color, religion, sex, disability, familial status, national origin, sexual orientation, or gender identity.
Liability, professional counsel, and legal provisions. The remaining sections of the agreement address important legal and risk management provisions. These include limitations on broker liability, disclosures regarding property surveillance, sex offender information, and a reminder that realtors are not acting as attorneys, tax advisors, or other professional service providers. Buyers should seek professional advice from appropriate experts when necessary.
Now that wraps up our walkthrough of SCR Form 130. This agreement is a critical document that defines the relationship between buyers and their real estate broker.
It also provides transparency about how buyer brokers are compensated and ensures that those terms are clearly disclosed and negotiated.
Stay tuned for our next video where we will continue walking through the key forms included in the March 2026 update. We hope this edition of the walkthrough helps you navigate Form 130 with confidence. Remember that these forms are designed to protect both the consumer and your brokerage, but they only work if they're filled out accurately.
However, we must issue an important warning regarding the unauthorized practice of law. Realtors are authorized to explain the standard language of these forms and fill in the blanks to reflect the intent of the parties. You're not authorized to draft original legal language or provide legal opinions or give advice about the legal consequences of a breach.
If a client needs a clause rewritten or a legal interpretation of their rights, they should contact a licensed real estate attorney.
If you're ever unsure about how a form should be used, don't guess. Lean into your broker in charge and call the SCR Legal Hotline at 803-772-5206.
Our team is here to help you Monday through Friday, and make sure you subscribe to the South Carolina Realtors YouTube channel so you don't miss the rest of our series.
For SCR Legal, I'm Byron King.
And I'm Tiara Pitts. Thanks for watching, and we'll see you in the next video.